Saturday is referendum day. Here to debate the Children's Amendment is Tanya Ward of the Children's Rights Alliance, who wants a yes vote, and Cathy Sinnot of the Alliance of Parents Against the State, who advocates a no. Good morning. You're both very welcome. Could we just talk about some of the key issues, and I'll give each of you an opportunity to sum up at the end your reasons for holding the views you do. Adoption, first of all. Cathy Sinnot, your group and you oppose the proposal to facilitate adoption. Why?
We're talking about forced adoption. No one opposes adoption. Adoption can be a really wonderful solution in a child's life. Forced adoption is a different thing. This is adoption against the wishes of the parents. This is adoption where the state steps in and forcibly adopts. That's my problem with it, but that's not my chief problem with this amendment. My biggest problem with this amendment is that it shifts the authority of parents to all parents, for all children, to protect and guide their children's development to the state. I
just want to stick with adoption for a moment. Okay. Tanya Ward, how do you respond to that? Forced adoption.
That's absolutely not the case. The referendum is about resolving a critical problem for hundreds of children who are locked in long-term foster care at the moment. They've been there for 5 years or more, and it poses real problems for the foster parents who are looking after those children. They can't give consent to medical care, they can't get passports, social workers have to give permission for those children to go on school trips, and those children want a permanent, stable family home. The reason why these children can't be adopted is because of what the Constitution says about the family, and the state has tried to address this through an Adoption Act in 1998 and failed. So if we don't pass this referendum, these children who are continuing to languish in long-term foster care won't be adopted by their families. They want to know after this referendum that their foster parents that they've been with for years will be their parents for life.
Sinnot?
Well, that's not the experience in the UK, and we do have to look at...
Yeah, they don't have a constitution. Can we just talk about what's happening here?
The only country in Europe that has involuntary or forced adoption is the UK, and we are absolutely blind if we don't look at what's happened. Tony Blair brought it in. What happened was it wasn't the children in long-term foster care that were adopted. It's now young children, it's toddlers, and it's babies, and it's forced.
That's absolutely
and last year there were 2,000 forced adoptions, and one MP,
it's not the case
1,700 of them
Can we talk about Ireland
absolutely illegitimate forced adoptions, and that there was no good reason for doing it.
The legislation has already been produced. These children will not be adopted unless their parents have abandoned them for 3 years and they've been with the foster families for a year and a half, and then the adoption authority has to agree to the adoption, and the adoption has to be done by the High Court. Completely different system to the UK.
I want to move on to the first part of this, which is first of all a statement that the state recognises the natural and imprescriptible rights of children, but then it goes on to say that the state will, in exceptional cases where the failure of parents is likely to prejudicially affect the safety or welfare of children, it will endeavour to supply the parent's place, but always with due regard for the rights of the child. Tanya Ward, what will that make possible that isn't possible now, and a good idea in your view?
It's absolutely a good idea, and what it does is it updates the language in the Constitution at the moment. It's not going to be a charter for separating families. There's very important safeguards there. It says in exceptional circumstances. That's in the Constitution at the moment, and it doesn't just focus on blaming parents. At the moment our Constitution focuses on the physical and moral failings of parents. This talks about the failings of parents, but it also talks about the safety and welfare of children, and we lobbied for the inclusion of the word proportionate, and that's a legal term, and what it means is the state must explore other alternatives before they take a child into care. This referendum isn't about taking more children into care. It's actually about making sure families get more support early on. A district court judge will want to see proof that the social workers have provided some form of support to families before they could ever agree to taking a child into care.
Cathy Sinnot, why are you against that?
Okay, look at the first. You said let's start with the first section. The first section is very clear. This is about all children. It is about the state becoming the agent that protects all children as opposed to the parents. In our present constitution, the state only comes in and takes the authority of parents when parents fail. In this constitution, in this amendment, the state takes the authority of parents for all children, regardless of failure, regardless of the fact that they're loving and caring parents. So this is a huge problem, and it's a revolutionary change. This is not a small adjustment. This is about every family.
What would it
and
make
changing
possible
the
in your
dynamic.
view?
Well,
That isn't
if you
possible
look
now?
at this, okay, if you look at this, the state is the one that's going to affirm the rights. Presently, the parents, the family affirms the rights of children as long as the parents aren't failing. And remember, we talk about rights here, but there's a whole new body of rights that go with this, and they're in the UN Convention on the Rights of the Child. And I have to congratulate Tanya, because the Children's Rights Alliance are the only ones that are coming clean on this and admitting that this is about the UN Convention on the Rights of the Child. So children will have new rights.
It is absolutely not the case, and it's been suggested there's some conspiracy.
What's absolutely not the case?
It's not the case that the role of parents will be undermined by this referendum in any way. The state cannot intervene unless the families fail. The definition of the family in Article 41 remains intact. The role of parents to provide for their children in Article 42 remains intact. And it has to be said, this referendum is supported by a whole range of important actors in society.
Right.
The bishops came out this week.
We know that. So, but anyway, Kathy Sinnot,
It's not intact.
If rights of parents are not taken out, which they're not, how will this, in your view, affect or injure them?
The rights of the family under Article 41 are absolutely gutted. It's gutted by the fact that the state will now affirm the rights of all children. It's right there, as opposed to the family. Okay, also because in all cases taken by the state against families, and in all family cases, what's called the best interest of the child, which is a legal term attached to the treaty I talked about, is that the best interest of the child, as decided by the state, is paramount. Now, paramount,
as decided by a court,
the word,
excuse me, as decided by a judge.
Yeah.
Surely
Well, a judge represents the state. No, as decided, not decided by parents, but that this judgment by the state or its agents, social workers, judges, whatever, is paramount. Now, paramount goes before anything else. That's a definition of paramount. So it's before the family, which is called superior and antecedent. It's before any other rights, because that is the definition of paramount. So the state's judgment on parents of failure or best interest of the child goes before the parent.
The only area in which the best interest will apply after this referendum is, number one, if the parents fail and the state has to intervene. And we have about 3,000 children at the moment who are in care under a care order, or in family law cases where parents are in dispute. The referendum only talks about the best interests in relation to childcare proceedings, guardianship, adoption, access and custody. And one of the important...
But that judgment will initially be made by social workers, by agents of the state.
Well, remember what happens is, in a childcare case, what happens is a referral is made to a social worker, and they're supposed to support the family as much as they can. But if they think that and really the only reasons a child can be taken into care is cases of chronic neglect, that's the biggest number, cases of sexual abuse and physical abuse, and they have to provide a serious amount of evidence before a district court judge will agree to a care order. That's not going to change because of this referendum.
Can I just turn to one other issue, the final section of this amendment, which says that in proceedings relating to custody or the welfare of children, the views of the child shall be ascertained. Do you have any problem with that, Kathy Sinnot?
We always want to know what the views of a child are. There are specific problems with that. Number one, there are things the taxpayer doesn't know. This also goes into the system of guardian ad litem, and that's fine, but often people are speaking. The voice of the child is often a lawyer that doesn't know the child. It's great when children do speak, but the two cases I know, two personally that I know of, where the child was asked to speak, in both cases the child was prompted. But we've got to come back to this. What are the one cases? Yeah, but what are the one kind of case that aren't in this amendment? Cases against the state for the state's neglect. The state has very conveniently brought in cases.
We're not going to talk about what's not in it. Just have you respond
it's a critical part of the amendment. We've got 17 official reports documenting our failures to protect children, and a common thread throughout those reports is that when children were abused, neglected and starved and they tried to complain, no one listened to them. And what this referendum will do, it'll mean that when children complain, when they say they've been harmed by an adult, that will actually listen to them. At the moment, only about 30% of childcare cases where children get to express a view, and that's true in a social worker who's acting independently on their basis.
I said I'd give each of you half a minute to sum up your reasons for advocating the votes that you do. Cathy Sinnot, first of all, why are you saying no? Okay,
I'm saying no because this is a complete shift in the dynamic of our society. This makes the state the controller of children and childhood. All children, loving families, caring families, parents. And this is not just about parents. The state takes control. It makes a decision of what's in the best interest of the child. It defines failure. And when a child is lost to a family, they're lost not just to the parents, they're lost to grandparents, often brothers and sisters, aunts, uncles. This is a complete revolution, and it's a most important amendment, and we're only getting one crack at this, and people need to vote no.
And Tanya Ward, your reasons for advocating a yes vote?
This referendum is about making sure our constitution gives our children the best possible protection it can. There is a huge consensus behind this referendum. The bishops, St Vincent de Paul has come out to support it, an unprecedented move. The INTO that works with teachers has come out to support it, an unprecedented move. The Irish Countrywomen's Association has come out to support it. They've all come out to support it because it gives us the best possible chance to protect children. And I think it gives us a chance to make sure that our values are reflected in the Constitution, that we value childhood, and it also gives us a chance to make sure that parents and children are given the best possible protection in the Constitution.
Tanya Ward and Cathy Sinnot, thank you both very much. It's coming up to 5 to 9.